Welcome to The Explainer. Today, we're diving straight into one of the most defining and honestly heavily debated topics in American history. We are going to untangle a 150-year legal web surrounding U.S. citizenship. We'll be looking at the roots of our laws, the history of the courts, and a fictional but highly illustrative modern scenario that brings this whole thing into focus. It really all boils down to this one fundamental high-stakes question. Who gets to be an American? It's a question that has literally shaped the demographics, the politics, and the civic life of the United States. Is citizenship a birthright simply by being born on the soil, or does it actually depend on the legal status and allegiance of your parents? To understand exactly how the law answers this question today, we have to map out a structural journey through the past and the present. Okay, let's dive into this roadmap. First, we'll cover the 2026 Supreme Court ruling. Then, the roots of birthright citizenship, followed by the Wong Kim Ark precedent. Fourth, we'll look at decades of legislative pushback. And finally, we'll go inside the court's opinions. Section 1. The 2026 Supreme Court ruling. We're actually going to start right at the climax of our story. On June 30th, 2026, in the case of Trump versus Barbara, the Supreme Court issued a major ruling. The court struck down Executive Order 14160, and by doing so, the majority reaffirmed the constitutional principle of birthright citizenship. They held that the 14th Amendment's Citizenship Clause guarantees U.S. citizenship to nearly everyone born on U.S. soil. And importantly, they ruled that this applies regardless of the parent's immigration status. This was a massive decision, mostly because it completely invalidated a major presidential executive order. So what exactly was that executive order trying to do? Well, published in January 2025, Executive Order 1460 directed federal agencies to deny automatic U.S. citizenship to certain children born in the United States. Specifically, this would apply if neither parent was a U.S. citizen or a lawful permanent resident at the time of the child's birth. The direct aim of the executive branch here was to exclude children born to unauthorized immigrants, as well as children of non-immigrants who are only temporarily present in the country, like those on temporary visas. And this brilliantly illustrates the tension between two foundational legal concepts at the very heart of this debate. On one side, you have Jus Soli, the right of soil, where citizenship is determined by birthplace. On the other side, Jus Sanguinis, the right of blood, where citizenship is acquired through the parent's nationality. The core legal battle in our 2026 case essentially asked, which of these concepts does the U.S. Constitution fundamentally rely upon? Section 2. Roots of birthright citizenship. To really understand how the court arrived at its modern interpretation, we have to rewind and trace this massive historical timeline. The concept actually begins way back with English common law prior to the Declaration of Independence. That system favored Jus Soli. Basically, anyone born in the sovereign's dominion was a subject. Fast forward to 1856, and the U.S. Supreme Court completely departed from this tradition with the infamous Dred Scott decision, denying citizenship to African Americans and stating they couldn't be part of the political community. Now, this dark chapter was explicitly overturned after the Civil War by the 1866 Civil Rights Act, and then it was permanently cemented into the Constitution in 1868 with the ratification of the 14th Amendment. Which brings us right to the text itself. The 14th Amendment states, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States. So the absolutely crucial point here is that middle phrase, subject to the jurisdiction thereof. That single short phrase has literally been the center of legal debate for over a century. Does it just mean having to obey local laws, or does it mean owing complete and total political allegiance to the United States? Now, you might be wondering, is this rule 100% absolute? Actually, no. The rule of birthright citizenship has always had recognized historical boundaries. For instance, children of foreign diplomats are excluded because they're under the jurisdiction of their home country. The exact same logic applies to children of hostile occupying military forces. And historically, as we'll see in a second, certain categories of Native Americans were originally excluded from this automatic birthright too. Section 3. The Wong Kim Ark precedents. To see how the 14th Amendment was ultimately applied to the children of immigrants, we have to look at a very specific real-world human story. In 1898, a man named Wong Kim Ark, who was born in San Francisco to Chinese parents, traveled abroad. When he tried to return to his home in the United States, he was denied re-entry by officials who claimed he wasn't an American citizen. Keep in mind, at this time in history, federal law actually made Chinese immigrants completely ineligible to become naturalized U.S. citizens. So for Wong Kim Ark, This abstract legal theory became a very real fight against exclusion. The Supreme Court actually took up his case, resulting in the landmark United States v. Wong Kim Ark's decision of 1898. The court ruled in Wong Kim Ark's favor, declaring that a child born in the U.S. to alien parents does indeed acquire citizenship by birth. This decision firmly established that the 14th Amendment incorporated the common law rule of Jus Soli, the right of the soil. The court made it crystal clear that this right applied regardless of the parent's race or nationality, setting the controlling precedent that we still use today. However, we've got to contrast Wong Kim Ark with an earlier case from 1884 called Elk v. Wilkins. In this case, the Supreme Court interpreted that highly debated jurisdiction phrase quite differently for Native Americans. The court ruled they were excluded from 14th Amendment birthright citizenship because they owed direct, immediate allegiance to their independent tribes, not the U.S. government. It actually wasn't until much later, through specific statutes in 1924 and 1940, that Congress officially granted birthright citizenship to all Native Americans. Section 4. Decades of legislative pushback. Despite that Wong Kim Ark precedent, this interpretation definitely hasn't existed without massive debate. Lawmakers, driven largely by concerns over unauthorized immigration, have consistently proposed various strategies to alter citizenship rules. Many have proposed outright constitutional amendments to limit birthright strictly to the children of citizens or legal residents. Others have tried statutory redefinitions of the Immigration and Nationality Act, basically trying to redefine the phrase subject to the jurisdiction to exclude the children of unauthorized or non-immigrant aliens. There are even extreme proposals, like denationalization provisions in draft versions of Patriot Act 2. These attempted to strip certain Americans of their citizenship entirely, moves that legal scholars quickly noted raised severe Eighth Amendment concerns regarding cruel and unusual punishment. Let's move to Section 5, Inside the Court's Opinions, and see how this builds together. Let's return to that modern 2026 ruling and really unpack the dueling judicial philosophies that define this issue today. Writing for the majority, Chief Justice Roberts affirmed the long-standing Jus Soli precedent. His core argument was straightforward: physical presence equals jurisdiction. Because non-citizens in the United States, even temporary visitors or those without lawful status, are required to obey U.S. laws and answer to U.S. courts, they are absolutely subject to the jurisdiction of the United States. Therefore, their U.S.-born children perfectly satisfy the 14th Amendment's requirements. Now, what's really interesting here is the powerful dissent from Justice Thomas. He argued that the majority fundamentally misinterpreted the original meaning of the Citizenship Clause. In his view, the 14th Amendment was a race-conscious remedial measure specifically designed for freed slaves. Looking at alternative historical sources, he argued that jurisdiction demands much more than just mere physical presence. It actually requires the parents to possess complete and primary political allegiance to the United States. And Justice Alito presented another highly impactful dissent that carries equal intellectual weight in this debate. He echoed the historical argument about political allegiance for sure, but he also heavily criticized the real-world implications of the majority's ruling. He noted his deep concern that guaranteeing birthright citizenship without considering the parent's legal status provides a powerful incentive to enter or remain in this country illegally. The concurring opinions are also super revealing about the broad spectrum of legal thought on the modern court. Justice Jackson wrote to specifically counter Justice Thomas, arguing that the 14th Amendment wasn't just some narrow remedy for freed slaves, but advanced broad, universalist, anti-caste principles meant to create equality for everyone. Meanwhile, Justice Kavanaugh took a much more technical approach. He agreed the executive order was invalid, but primarily on statutory grounds, not constitutional ones. In fact, he suggested the Constitution wouldn't necessarily prevent Congress from passing new laws to create exceptions to birthright citizenship in the future. Finally, our last section, conclusion and future implications. So after walking through English common law, the 14th Amendment, Wong Kim Ark, and this 2026 decision, what should you actually take away from this 150-year journey? Well, here's why this matters. By striking down the executive order, the 2026 ruling preserved a constitutional understanding that has shaped the nation's identity for over a century and a half. It provides profound certainty to generations of American families, establishing clearly that citizenship is determined by the bedrock of the Constitution, not by the changing winds of executive policy. Ultimately, this ruling shifts the national focus away from endless courtroom litigation over birthright and toward the practical, on-the-ground reality of immigrant integration. I want to leave you with this final provocative thought. If the constitutional question of birthright citizenship is truly settled by the court, how will America pivot? How will we address the much broader, incredibly complex challenges of immigrant integration, community building, and comprehensive reform? It is a question that will undoubtedly define the future of civic life in America. Thank you so much for joining me for this explainer, and keep asking the big questions.